is Heather, and as you can see from the thumbnail, this is episode 19, Morrissey's Misconduct and More Shenanigans by the State. And this is the case of the Canton Cover-Up, Commonwealth versus Karen Reed, and also Aidan, Turtleboy Kearney. I have added him because he is just as much a part of this case as Karen Reed is, because the Commonwealth has made him so. And we'll get into him a little bit later, but first let's start with the Memorandum of Decision and Order of Defendant's Motion for Sanctions and for Disqualification of the Norfolk County District Attorney. So, if you're following along with this case, you probably already know how corrupt the Norfolk District Attorney's Office is. We're going to talk about it, or we're going to read through this, and big surprise here, and spoiler alert, Judge Canoni denies it. So I'm not going to read through this this is all, background that we've read through 100 times in other filings. Basically, Karen Reed is being charged for backing up into and unaliving her boyfriend, Boston police officer, John O'Keefe. Sorry, I'm having a brain collapse here. Okay, so Officer O'Keefe is found on the lawn, unconscious, at 6 in the morning. And we've got some drinking going on, and they think that, Karen backed up into him. But none of the evidence shows that, and all of his injuries are consistent with being in a fight with humans and a dog. So if you look at the evidence, it's clear as day to me. So basically, that's what this whole, part is saying. That's the side of the Commonwealth, and then Karen's side is that they are claiming that the Norfolk District Attorney is corrupt, should be dismissed. They're asking for either the dismissal of the charges altogether or for the disqualification of the Norfolk District Attorney's Office, or the NDAO. Also, here in the document, we'll call it that. And the court concluded that there was no egregious misconduct occurring that is reasonably or substantially likely to materially prejudice or interfere with the defendant's right to a fair trial. The court will deny the motion. So there you have it. This is the discussion. The defendant's arguments for dismissal and disqualification. The defendant advances two arguments in support of her motion. First, she contends that a video statement issued by D.A. Morrissey on August 25th of last year violated the Massachusetts rules of professional conduct and her right to receive a fair trial. Second, she argues that the Norfolk District Attorney's Office failed to disclose information regarding an investigation by the U.S. Attorney's Office, USAO versus NDAO. Okay, confusing. All right, so, and they left out, they failed to disclose exculpatory information as well. So the defendant argues that these instances of misconduct warrant dismissal of the indictments or disqualification of Attorney Michael Morrissey's office. So D.A. Morrissey's statement: this case has generated significant media attention and public scrutiny in large part due to statements made to the media by defense counsel. And this is arguably false. It's not from defense counsel. It's because of the nature of this case and the fact that it has to do with corruption and corrupt cops and corrupt attorneys in Norfolk District. All right, so on June 9th, 2023, the Commonwealth filed a motion to prohibit prejudicial extrajudicial statements of counsel in compliance with Massachusetts rules of professional conduct in response to multiple media statements by the defendant's counsel in which they accused witnesses of being involved in O'Keefe's unaliving and engaging in a cover-up of a crime. So the Commonwealth filed that motion after this theory came out, and the Commonwealth did not want that theory coming out because it is the truth. So that's why they wanted a gag order, basically. So while the court acknowledged that the statements at issue were arguably inflammatory and appear to have fueled much of the publicity in this case, which I seriously doubt. It's always the state that has the actual narrative. And usually you don't hear from the defense until their opening statements. In this particular case, we just happened to have Turtleboy, who was an intermediary between the defense and the public, and gave us the information that was necessary to see this case for what it actually is. All right, so the court issued the decision on the 25th of July. And a month later, remember, Morrissey is going to make his recorded statement. So while the court acknowledged that the statements were inflammatory, blah, 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 it determined that they were generally in response to the accusations against the defendant, and that at the time when the trial date had yet to be scheduled, an order limiting defense counsel's statements was unnecessary. In doing so, the court reminded defense counsel and the Commonwealth of their obligation to adhere to the rules of professional conduct. So basically, they were reminded. Nicely means, you better do as I say. To follow the rules of professional conduct. Again, that was a month before Morrissey then made that prejudicial statement. So on the 22nd of 2023, ABC aired a Nightline News segment in which defense attorney Alan Jackson reiterated the defendant's theory of the case, and that is their strategy. They're allowed to say their strategy. So the fact that they were on TV and telling the world their strategy, the defense of their case, that's not illegal. It's not wrong by any means, and they have a right to talk to the media. Anyways, so because I guess Alan Jackson talked to the ABC Nightline, she didn't like that. Judge Bev Canoni doesn't like that. So the evidence was planted after the fact. Oh, Alan Jackson reiterated that the defendant's theory of the case is that the evidence was planted after the fact that O'Keefe was physically beaten and his life ended in the Albert house and placed outside, and that there was a cover-up of the crime. According to Attorney Jackson, O'Keefe's appearance in the autopsy photograph supports this theory, and it absolutely does. You can see in the autopsy he's got the knuckles where you would hit someone. It's all banged up and bruised and swollen. His whole palm is swollen, or not palm, the outside surface or the top surface of his hand is all bruised, and his eyes are all swollen, and face badly swollen and bruised. And funny, no injuries below the waist, which is probably where a car would hit you, right? I don't know. So anyways, the August 25th, 2023, D.A. Morrissey, on August 25th, I don't know what I said. On August 25th, 2023, D.A. Morrissey issued a public statement about the case. He began by stating that the harassment of witnesses in the unaliving prosecution of Karen Reed is absolutely baseless. And then he goes on to say a whole bunch of other things, and we're going to actually listen to it right now. So let me flip my screen over, and here we go. There's Michael Morrissey. Just know that there's a lot of lies that are in this statement that he makes here.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that his phone did not enter that home.
Then why did his Apple Health data, which is fairly accurate, why did that show that he went up and down 3 flights of steps at some point after 12:30?
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street.
We don't know that. We do not know that. And it's just really weird and convenient that everyone's coming to Brian Albert's house to party, yet individuals like Colin and Caitlin happen to just leave right at that time when everybody's showing up. It doesn't make sense to me.
This is a false narrative.
And why are Caitlin and Colin leaving at like 12 at night? Why are they leaving their house at 12 at night? Like, that isn't normal either. That's not normal behavior, so.
Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community?
But you're not giving Karen the presumption of innocence in your statement here, buddy.
They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
A desperate attempt to reassign guilt. Even though all the evidence points to the defense's theory, They just want to say that we're trying to, or that the defense is trying to reassign guilt.
Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
That's a lie. We've found out since then that is a lie.
Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so.
Well, let's break that down. The first search of the area, the crime scene, was from Canton police. They found broken pieces of cocktail glass and John's or somebody's BLOOD in the snow, and they collected that in red Solo cups because they're very professional over there. So that's what they did. And after the Canton police left, the case was reassigned to the state police, Massachusetts State Police, and Trooper Proctor. And I believe it was Trooper Proctor, or it could have been Tully. They called the unit, the search unit first, and said, "You can't come yet. We'll call you when you can." And there was a lapse of time in between where Michael Proctor could have easily gone and planted pieces of taillight anywhere in the vicinity after he had the SUV in his possession, which he lied about the time that he got the SUV. He lied about its condition and how the tail light looked. And later there was another cop who actually, and this might be hearsay, I don't know if this is in any court document or anything, but I heard that there was another cop who was asked because the vehicle was towed to Canton PD, which they were excluded from the case because of the fact that Kevin Albert is the brother of Brian Albert and he's a Canton police officer. So there's just too much of this going on where everybody knows everybody, except Karen doesn't know. She's not in with the in crowd, so they have to blame her because she's the person on the outside. It's just crazy.
Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation.
The reason would be to protect your friends, obviously, and they are close friends, and we know this now. It's undeniable. And Trooper Proctor recently went to a grand jury. He's been called back to a grand jury to answer to his relationship with the Alberts, and he admitted fully on the stand that he lied about his relationship with the Alberts and that Yuri Buchanan knew about his close relationship to the Alberts. So, yeah. So that just came out this, I believe, February was when he was in the grand jury, or when he was asked to come back to the grand jury to testify.
Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the process.
It's because he wants to narrowly tailor his message to Turtleboy and all the Turtleboy followers, because he doesn't want this message getting out that it's okay to talk about the fact that another police officer may have been involved in this. That's what they want to silence. And he did it in a pre-recorded message like this because they didn't want to answer questions. Let's face it, they didn't want to answer questions. So that's why they sent this. We have somebody requested the FOIA of the data of the emails, and of the district attorney office's emails, and there are emails of this going out to like all the news people in that area, all the local folks, so that it would air.
Prosecution is pending in Superior Court, but the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
So there you have it. It needs to stop. I love the Boston accent. I'm really becoming very fond of it because I've been watching so much Turtleboy and other people, other creators in that area who have been, taking on this case. And I really have become very fond of the Boston accent. I wish I could do it myself, but I can't. All right, so let's continue on with, make this a little bit bigger. So we don't have to read his statement now because we just listened to it. So about 3 weeks after this statement, the court scheduled the trial date for March 12th, 2024. All right, so the foregoing is not a recitation of the full statement. All right, but we just watched the full statement. And the trial date, it has since been rescheduled to April 16th. So it's coming up fast. 16, 17 days away. All right, so where were we? All right, the defendant argues that D.A. Morrissey's statement violates the Massachusetts Rules of Professional Conduct pertaining to trial publicity and the special responsibilities of a prosecutor. It absolutely does. In relevant part, Rule 3.6 states, a lawyer who is practicing or has practiced in the investigation or litigation of a matter shall not make any extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have the substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So far, I think it meets all of these qualifications. All right, so notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. But these aren't the lawyer's clients. The Norfolk District Attorney does not represent the witnesses. They represent the state. They have their entire intents and motivations are to better the state. They don't care about the witnesses' rights and feelings and whatnots. They don't care. They don't care about victims often. They care about the state and what's better for the state and how they're going to get people prosecuted, sometimes wrongfully. I have very little trust in our judicial system after seeing so much of this unfold. All right, so anyways, did I read that? Notwithstanding, a statement made pursuant to this paragraph shall be limited to such information as necessity to mitigate a recent adverse publicity. So I guess they're saying that he could make that statement after the ABC statement. That's what she wants to refer to here. So in relevant, after Alan Jackson made the statements on Dateline, then the Commonwealth was okay to respond that way? I don't agree, but that's what I think Judge Canoni is saying. So in relevant part, Rule 3.8 states that a prosecutor in criminal case shall, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's actions and that serve a legitimate law enforcement purpose, or refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. He flat out says Karen's guilty and my witnesses are innocent. I guess he does think of them as his clients. The witnesses are innocent. refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6, and take reasonable actions to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making. So other people on the case, like um, law enforcement, or your expert witnesses or whatever, your investigators shouldn't be making extrajudicial statements either. While DA Morrissey's statement, when viewed as a whole, appears intended to both rebut defense counsel's accusations in the Nightline interview using evidence from the investigation and to prevent further witness harassment, some of his comments are clearly inconsistent with the rules of professional conduct. So she admits he is violating professional conduct. Let's highlight that. In particular, his comments about witnesses that relate to their credibility are the type of extrajudicial statements that are more likely to have a prejudicial effect on the proceeding. So he did exactly what I said. He met all the requirements in that first paragraph. In particular, his comments about witnesses that, I just read that, sorry, Morrissey's statements characterizing the defense theory as a desperate attempt to reassign guilt and as a lie also runs the risk of heightening the public condemnation of the defendant. I'm glad she pointed that out because it's true. But there was so much more that he said that was also running the risk of heightening the public condemnation of her defendant. All right, so the contentions of the defendant in this regard are non-trivial, she says. Non-trivial, so they're not important. However, the court finds dismissal of the indictment is not warranted. Absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. That, I think, it is a serious threat of prejudice. Anyways, she disagrees. Though certain comments by D.A. Morrissey cross the line of permissible extrajudicial statements by a prosecutor, they are not egregious misconduct that is reasonably or substantially likely to materially prejudice or interfere with a trial. Much like the defendant's statements addressed in the Rule 3.6 decision, D.A. Morrissey's August 25th statement occurred before a trial date was scheduled and is less likely to materially prejudice the proceedings. How does that fucking matter? I'm sorry. I try not to swear on my channel, but how does that effing matter? How does that matter that it was said before the trial date was set so it doesn't prejudice anyone? Baloney, I call. See Restatement 3rd of the Law Governing Lawyers. A statement made long before a jury is to be selected presents less risk than the same statement made in the heat of intense media publicity about an imminent or ongoing proceeding. But she said herself that this has been a lot of intense heat in the media for this trial. So she's saying that she's contradicted herself. Where's her footnote? Although the court recognizes the seriousness of D.A. Morrissey's misstep, this is not the case, for instance, where prejudice from counsel's improper vouching for a witness occurred during trial and thus tainted the entire proceeding. In a case such as the present one, which rested entirely on the credibility of the complaining witness, we cannot say with assurance that the improper closing argument could have influenced the jury to convict. So that was what she was citing there. All right, so while D.A. Morrissey has responsibilities as a prosecutor, that defense counsel does not bear, the court can mitigate any potential prejudice of his comments through jury voir dire. So the court is saying that if he is showing any prejudice, which, I mean, she's saying that he is, but okay, so has responsibilities as a prosecutor that defense does not. The court then will help get in the middle if D.A. Morrissey is being too prejudiced of his comments while eliminating jurors. Jury voir dire is when you select your jurors. So she's saying the court can mitigate any potential prejudice of his comments through jury voir dire. So any prejudice that was out there, the court can mitigate it. She's saying that it wasn't that serious. She can talk to them and it'll be fine. I don't believe, but okay. Risk from substantial pretrial publicity obviated by individual voir dire. Dismissal of the indictments is therefore not appropriate. Dismissal of criminal charges is a remedy of a last resort. But this is the last resort. I mean, this case is severely wrong on so many levels. Nor is disqualification of the Norfolk District Attorney's Office required. Disqualification of counsel is not a measure to be taken lightly. Commonwealth versus Scanlon, it is only appropriate where an attorney's continued participation as counsel taints the legal system or the trial of the cause before it. Well, I think it is tainting a lot of things by having Morrissey there. Complete disqualification of an entire district attorney's office, moreover, is highly unusual. See Commonwealth versus Holly. Complete disqualification of an entire district attorney's office unnecessary where a lawyer who previously represented a defendant in unrelated manner joined district attorney's office prosecuting him. All right, so contrary to the defendant's assertions, nothing before the court suggests that the district attorney's office has any interest in the outcome of the prosecution other than the interest of justice. Really? Because he clearly thinks Karen's guilty. He just said it. So how can you say that he doesn't have any interest in the outcome? I don't know. All right, and it won't affect her fair trial. All right, so while D.A. Morrissey's statement undoubtedly reflected poor judgment, there is no apparent conflict with the Norfolk District Attorney's Office, such as its continued participation in the case would taint the legal system or the trial. Disclosure of federal investigation. In November 2022, the USAO, United States Attorney's Office, began an investigation into the unaliving of O'Keefe and prosecution of the defendant. And if anybody's following along with the Sandra Birchmore case, that is also very much related because it's very similar investigators involved. And I believe that the FBI was probably investigating them because of the Sandra Birchmore case and just happened to intercept information on the Karen Reed case potentially. I don't know, but that's my feeling on it because Sandra Birchmore was a young girl very much groomed by law enforcement to at a young age. I'll just say that. She was very much groomed by older men in law enforcement, and she was having a baby and committed a self-deletion, but I don't think she did. And the way that she was, it's very questionable, and there's security footage of what looks like a man coming in and out of her apartment, and that's a crazy case all in and of itself. I recommend you go check that out. I have not covered that yet on my channel, but one day I'm sure I will because it has a lot of the same players in here. So anyways, back to what we were reading. The federal investigation. On May 9th, 2023, the Norfolk District Attorney's Office wrote a letter to the United States Attorney's Office regarding the issuance of federal grand jury subpoenas to at least 2 witnesses to the Commonwealth's investigation into the unaliving of John O'Keefe. The letter stated that the Norfolk District Attorney's Office had a constitutional duty to provide the defendant with exculpatory evidence, and that to fulfill that duty, it was requesting discovery of all statements of witnesses to investigators and the grand jury. The letter further stated that the Norfolk District Attorney's Office had a duty under Massachusetts R. Crim P. 14 to notify defendant when it became aware of that such statements exist. So they should have already handed that, or they're blaming their requirement to turn over discovery in a timely manner to the defendant. They're saying that that is the reason why they were asking for all these things. But really, they just wanted to know what the grand jury knew. The Norfolk District Attorney's Office acknowledged that it was unaware of the parameters of the federal activity, but willing to file for protective orders to fulfill its constitutional and state disclosures. All right, so on May 18th, 2023, DA Morrissey wrote a letter to the Office of Professional Responsibility at the U.S. Department of Justice requesting that the USAO's investigation be examined by the OPR or transferred to another office without a history of conflict, bias, and ABUSE of prosecutorial discretion. I can't say that word. All right, so the letter stated that the NDAO learned of the federal investigation approximately 3 weeks ago when multiple state witnesses were contacted by the FBI and received subpoenas to appear before a federal grand jury. DA Morrissey further wrote that the Norfolk District Attorney's Office had communicated with the U.S. Attorney's Office that it was trying to comply with its discovery obligations to the defendant, but that the USAO had offered the opinion that you can't turn over information that you don't have. The NDAO, however, had confirmed that witnesses had testified and was again requesting it be provided with information so it could fulfill its discovery obligations. So basically, they're like, you don't have the information, so you can't provide it. So get out of here, Michael Morrissey. And then they ask for it again. So on June 1st, 2023, the OPR responded to the May 18th, 2023 letter declining to take any action. On June 12th, the USAO responded to the May 9th letter stating that it had, I couldn't tell what that word was. It had no issue with the Norfolk District Attorney's Office advising defense about the contact between the two if disclosure was warranted, and that it would be back in touch as circumstances dictate. On October 12, 2023, the Norfolk District Attorney's Office sent another letter to the U.S. Attorney's Office notifying them that a trial date had been set and that the Norfolk District Attorney's Office was again requesting, to the extent they may exist, statements made to investigators and grand jury minutes to fulfill its mandatory discovery obligations. On December 4th, 2023, the Norfolk District Attorney's Office provided the defendant with the letters exchanged between the Norfolk District Attorney's Office and federal offices between May 2023 and November 2023. The notice of discovery indicated that the Norfolk District Attorney's Office had not received any information about the parameters of the federal investigation or confirmed that witnesses had testified before the federal grand jury. On February 21st, 2024, the Commonwealth and the defendant received approximately 3,000 pages of confidential materials pertaining to the investigation conducted by the USAO. The materials were produced in accordance with the protective order. So we finally got 3,000 pages of information February 21st of this year from the federal agents. So now we know that there's a lot of information on this case that the feds were working up. All right, so the defendant contends that the Norfolk District Attorney's Office violated Massachusetts Rules of Professional Conduct 3.8 because it knew about the federal investigation for 6 months before it disclosed information to the defendant in December 2023, and that the proper sanction is dismissal or disqualification. The court does not agree. Imagine that. Rule 3.8 requires a prosecutor make timely disclosure of the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. Nothing before the court demonstrates that the Norfolk District Attorney's Office violated Rule 3.8d. The correspondence between the Norfolk District Attorney's Office and the USAO suggests that while the Norfolk District Attorney's Office was aware of the existence of the federal investigation, that some witnesses had been subpoenaed to testify before the grand jury as of May 2023, it had little to no information about the investigation and was unaware of what, if any, evidence the USAO had obtained. Indeed, the letters written by the NDAO and the USAO reflect an ongoing effort by the NDAO to obtain information about the federal investigation so it could produce such blah. So she believes they're BS. She believes they're BS that it was for discovery obligations. Liar. Liar. You know the truth, Bev. Come on. The existence of the federal investigation alone was not evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offenses. All right, so even if information as to the existence of the federal investigation was exculpatory, the defendant has not demonstrated to the court that the delay in disclosure prejudiced the defendant such that dismissal or disqualification is warranted. Indeed, on May 3rd, 2023, Attorney Jackson stated in this court that, quote, it had been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of the circumstances. The defendant had the same information that the Commonwealth had in May of 2023, that a federal investigation was ongoing and witnesses had been subpoenaed to testify before a federal grand jury. When the USAO finally did release information it had obtained during its investigation, it did so to both parties at the same time. Accordingly, any delay in disclosure by the NDAO does not require the drastic sanction of dismissal or disqualification. Her footnote says, the defendant also contends that when the Norfolk District Attorney's Office disclosed the existence of the federal investigation, it misrepresented that it was unaware that witnesses had testified before the grand jury. Even if the NDAO had such knowledge, the defendant has not shown that the misrepresentation prejudiced her right to a fair trial. Canonian does not change her mind very often. All right, so conduct of counsel and extrajudicial statements. In their opposition to defendant's motion, the Commonwealth has renewed its request to impose an order restricting extrajudicial statements or extrajudicial dissemination of evidence until a verdict is returned. Although the court denies to issue such an order, it stresses once again that both the Commonwealth and defense counsel must adhere to the rules of professional conduct concerning extrajudicial statements. This includes Attorney Jackson, who has had the privilege of practicing in the state on a temporary license granted to him by this court. Basically meaning, I brought you into this world, I can take you out. You know, that saying that your parents always said to you. That's what she's saying here. I let you come out of the kindness of my heart to come here and practice because you don't have a license in this state. So, you better shape up or you're not going to be able to practice here anymore. That's basically what she's saying there. So in addition to counsel's out-of-court conduct, the court also reminds counsel of their legal and ethical obligations while appearing in this court. For example, it is unacceptable for counsel to misrepresent or distort facts in impounded documents, to file an arguing motion without required supporting documentation, and to fail to comply with orders of this court, all of which have happened in this case. The trial now is imminent, and the court will not tolerate actions by counsel which waste the court's time and resources or violate the rules. For the foregoing reasons, the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney is denied. Signed March 28th, 2024, Beverly J. Cannoni, Justice of the Superior Court. So there is her order and decision to not disqualify Michael Morrissey for being a corrupt MFer, because that's what he is. Sorry, why is this thing so loud? Sorry about that. All right, so the next thing we're going to go over is basically, so this is a blog post from Aidan Kearney. This was a couple days ago. He posted this. Attorney Tim Bradel files spicy motion after discovering Ken Mello has been hiding grand jury documents used to indict Turtleboy. So there was another grand jury that was held for Turtleboy's case, which is a separate case, and then he's being charged on all these counts of witness intimidation and other things for like a rolling rally, for having a peaceful rolling rally, and where he did absolutely nothing wrong. He never violated the law in any way, let alone, well, this statute that they're citing that he broke is unconstitutional to begin with. But so here, I'm not going to read the whole blog. I just kind of wanted to sum up for you. So Ken Mello hasn't been giving over all of the discovery. There is grand jury testimony in Turtleboy's witness intimidation case, and Tim Bradel has been asking for this over and over again, and it is not. They're not doing it. Ken Mello is basically sitting on his butt, not doing anything in this case. They do have the grand jury minutes or transcript from Brian Tully, Chris Albert, Elizabeth Proctor, Michael Proctor, and Yuri Buchanan. They still have yet to receive the following grand jury testimony from Colin Albert, Brian Albert, John McCabe, Matt McCabe, and John Fanning, John Fanning is one of the investigators in the Sandra Birchmore case. I believe he was actually the lead investigator, so if that shows you anything, him and Buchanan actually just went to a woman's house because she sent Colin Albert a text to tell him to tell the truth in his testimony, basically, to law enforcement. And so now Buchanan and John Fanning have been going around trying to hunt this woman down and find her, and they can't find her address, which I think is funny. They've been tracking down family members to find her. And it's scary. That's scary stuff. Like, man, you put Turtleboy in prison or in jail for 60 days just for speaking the truth. Anyway, so this is an email that Tim Bradel, so he's had enough of Mello's crap, and says this in an email to Mello just recently. So, discovery failures. Attorney Mello, it has come to my attention that the Karen Reed defense team is in possession of grand jury minutes from our matters that you still have yet to provide to me as counsel in the case of record. So it's the case of record. You have grand jury minutes for the case of record, and you're handing them over to Karen Reed, who, like, okay, yeah, they should have it too, I guess, because there could be things in there that help them. But why are you turning it over to her and not me? How am I supposed to be able to prepare for my case if you're not turning it over to the person whose case it is? That makes no sense. So we have been asking these crucial discovery documents for months. You have only provided piecemeal discovery. It is unprecedented and frankly astonishing that an officer of the court you would serve these on others and continue to withhold the full set of grand jury minutes from the very target of the indictments. All the more so when we recall that in extracting my mid-February assent to your request to continue the pretrial, you agreed that you would get me the discovery as soon as possible. You make promises and discard them like yesterday's trash. Finally, you have ignored several emails to this effect. You've also ignored my recently filed motion to compel discovery. Your co-counsel to the matters, Mr. Novak, can fill in to the extent you have other issues. It takes about 3 minutes to send an email and attach the relevant documents. Why this has not occurred is a mystery. Actually, that is giving you too much of the benefit of the doubt. We both know exactly why you are withholding these particular items, and I find it extremely inappropriate that you're in possession of this discovery and have provided it to another defense team while intentionally neglecting to provide it to the individual that you've gone out of your way to prosecute on these unprecedented charges that make a mockery of the First Amendment. You also have failed to provide the contents of my client's cell phones, which you are also refusing to provide on specious grounds. Regardless of your position on giving his actual phones back, there's no question that you owe us the contents of those items as mandatory discovery. I am asking you to provide these items today, or I will take further action next week. It would be appreciated if we can conduct the balance of this prosecution in a normal professional manner. Timothy J. Bradel, Esquire, Law Office of Timothy J. Bradel. So that was his statement or his email, basically to Ken Mello, because Ken Mello is not turning over the discovery. And this is the motion filed in response to that. So defendant Aidan Kearney's motion to compel overdue automatic discovery. Now comes defendant Mr. Aidan Kearney by and through undersigned counsel and respectfully requests that the court order the Commonwealth to produce overdue mandatory discovery. Under Mass R. Crim P14, mandatory discovery was due at or before the pretrial conference. Here, discovery was due at that time by agreement of the parties when Commonwealth counsel asked for defense counsel to assent to a continuance of the 216 pretrial conference. Sorry, my mouth is not taking shape of the words. The Commonwealth counsel agreed in return to provide said automatic discovery due on said pretrial conference, but did not honor that agreement. Since their agreement, Commonwealth counsel has ignored several defense team requests for compliance. Instead, the Commonwealth has provided sporadic, piecemeal, incomplete, and insignificant discovery and failed to provide the main items due, such as all of the grand jury minutes so the defense can prepare an Odell/McCarthy motion, all of the reports in the case from all departments, all of the witness interviews, a list of physical evidence, and the like. So all of the mandatory things that you're supposed to turn over to the defense, you're not doing. Why aren't you doing this, Ken Mello? The Commonwealth has provided digital files with nothing in them, files containing 3 copies of the same item, and nothing additional. Gigabytes of photos of defendant's own home, and the like. There are several missing MSP, Massachusetts State Police, case reports, and several indications that a large portion of the grand jury presentation is yet to be provided. Although it is not the defense's job to audit the Commonwealth discovery and guess what is yet to be provided, the defense team has spent a great deal of time communicating with the Commonwealth to identify missing items and make compliance as easy as possible without much more than a scintilla of cooperation from the government. There is clear avoidance of responsibility here, motivated by likely reluctance to provide evidence harmful to the government's case. Email dates are as follows, where the defense team has made requests for compliance. 2/27/24, request for grand jury minutes and missing files within the case report. The next day, 2/28, request for grand jury minutes and items referenced in discovery regarding Colin and Chris Albert. Any and all statements referencing repeated mentions of the Alberts and accusations of them being responsible for the unaliving of John O'Keefe and taken part in the cover-up. Any evidence pertaining to the Alberts' addresses and personal phone numbers being released by Kearney. Evidence of Mr. Kearney's readers, followers, and supporters that have also engaged in harassment by placing over 50 false orders per day at D&E Pizza and Subs and never paying for the food. So he wants proof of that. Don't just say that you... So Chris Albert, the owner of D&E Pizza, is saying because of all of this... he's getting 50 false orders a day for pizza and people ordering food and not paying for it. Well, show us the proof of that. Show us your call records. Show us that you're getting those in the name of turtle writers. He can't. So there you go. Threats of retribution, records, or so this is all the stuff that they've been asking for on the 28th. This was an email that went out. Okay. So evidence of Mr. Kearney's readers, followers, and supporters that have done that to D&E, threats of retribution, readings or photos of recordings, or photos of Colin Albert being followed and recorded leaving his home. Items referenced in discovery regarding complainant Lindsay Gattani, screenshot that Kearney allegedly sent her showing multiple calls on a certain day that showed Karen Reed's signal audio in the call log. So all of these are things that they're lies because they don't have the evidence to produce it and the state can't back it up. Any and all text, phone call, and voicemail records between Attorney Mello and Lindsay Gattani and Brian Tully and Lindsay Gattani. So any of the communications between Lindsay and law enforcement or the prosecutor in the Aidan Kearney case trying to conspire to put Kearney away to get him on a violation so that they could lock him up. That's what those phone records are for. Any and all call logs and recordings of communications, 911 or business line calls between Mello and the Medfield Police Department and Brian Tully and the Medfield Police Department, because Gattani lives in Medfield. Copies of the reference notes that Lindsay Gattani misappropriated from Mr. Gattani. So the notes that she took from him, wouldn't let him have his property. Where are they? Give us a copy of them. 2/28/24, response from ADA Mello saying he's ill. 2/28/24, request for co-counsel Novak to provide since Novak can indict and attend hearings on behalf of Mello in this time frame. 3/1/24, follow-up request with specific discovery requested. 3/6/24, another follow-up request. If the court wishes to wade further into the particulars, emails are available on request. During this time frame, the Commonwealth has been able to further indict Mr. Kearney, seek to jail him, arraign him on new charges, speak to the media, investigate third parties exercising their First Amendment rights to speak about the case, looking for links to Mr. Kearney, and several other endeavors. So anyone that wants to speak out on this case, they want to link them to Kearney and say that they're conducting witness intimidation too. Mandatory, and they're trying to get it against Kearney. So if I know Kearney and I'm saying things to the witnesses to tell them the truth or whatever, and they want to get more charges on Kearney, they're going to come to me and try to break me so that they can get more charges on Kearney and get him put away, because that's what they want ultimately, is to shut him up. And they couldn't even shut him up from prison, so there's no point in trying to get him locked up again. Mandatory automatic discovery for the defense has not been on their to-do list and takes a backseat to further oppressing Mr. Kearney and anyone who utters a word in support or in criticism of the same investigating officers. Court involvement has become necessary as the administration of justice has been stalled by the government. Mr. Kearney and counsel believe the Commonwealth is deliberately withholding most or all of the foregoing automatic and exculpatory discovery because it provides sworn falsehoods and would be the basis for a motion to dismiss for egregious governmental misconduct. Wait, say that again? So Mr. Kearney and counsel believe the Commonwealth is deliberately withholding all of these things and foregoing automatic discovery and exculpatory discovery because it contains sworn falsehoods from the witnesses and would be the basis for a motion to dismiss for egregious governmental misconduct. Which we were supposed to see. I was so excited to see that motion come from Jackson or Yannetti, but it never did for Reed's case, and now it's possible there might be one coming for Kearney's case. And he should absolutely go for egregious governmental misconduct because of the way that they treated him and for imprisoning him just to silence him. This belief is based on the overlap between the instant case and the Karen Reed Norfolk County prosecution, wherein officials are accused by the FBI and federal grand jury of making false statements to the grand jury, and that similar or the same suspects' statements were repeated or elaborated upon by additional investigators in the Aidan Kearney case. As a result, the government is stalling the production of these central items in favor of providing secondary or irrelevant discovery to appear in good faith. Damn, okay. So the addition to the items requested above, the following mandatory automatic discovery has not been provided. Number 1, all exhibits listed in grand jury transcripts from December 14th. Number 2, all exhibits listed in grand jury transcripts from December 20th. Number 3, all of the dates for grand jury minutes, only dates received were December 14th and the 20th, based on references in grand jury provided. Prior and future grand jury dates were referenced. The defense believes there are many dates and witnesses that have been withheld. All exhibits listed in each of the grand jury minutes to be provided. 5, all exculpatory evidence. 6, certificate of discovery providing formal notice of items provided. So they have to certify, not only do they have a requirement to turn over all discovery that is necessary, all discovery that is exculpatory, they have a duty as a person, legally sworn, duly sworn, as someone from the court, they have a duty to turn over all that evidence. But then they also have to certify that that evidence that they're turning over is correct and to the best of their knowledge, everything that they have. And Ken Mello can't do that. And neither can Adam Lawley in the Karen Reed case. They're still turning over evidence and have not certified. Alright, so such information is relevant and exculpatory and mandatory discovery under Rule 14 of the Massachusetts Rule of Criminal Procedure. Mr. Kearney relies on Brady versus Maryland, Kiles versus Whitley, Commonwealth versus Adjutant, Weary versus Kane. Exculpatory evidence in possession of charging police department must be automatically disclosed under Brady versus Maryland, Kiles, and Whitley, and all applicable Commonwealth and federal constitutional and statutorial guarantees. Wherefore, the defendant requests an emergency order requiring full Rule 14 compliance within 7 days of March 19th, or an immediate hearing for this motion should be set, and other motions on file. So, that's not the only motion that Aidan has on file, but this is a big one because they're hiding information, and that information is probably all lies, and that's why they can't back it up. So if they do try to provide some kind of evidence, it's going to be falsified or not accurate in some way. And they're just trying to throw like little bits and pieces here and there of discovery every now and then, like, oh, here's a statement we forgot to send you from blah blah. But really, they're just delaying the process. It is egregious, in my opinion, to withhold this information. They have a duty to hand it over, and I'm so sick of seeing the power behind the state and them not even turning over the discovery that's needed in many cases here. And it's really disturbing. If it can happen here, it can happen in any town. And it doesn't take multitudes of people to get it done. It could take just one or two bad apples in the system, and your liberties can be taken away from you very easily, just like Turtleboy's. For 60 days, he had to sit in prison. He missed Christmas with his kids. He missed Super Bowl parties. He missed things in his life. He missed New Year's celebrations with his family and his kids. He missed taking his kids to school every day. And that's something that he'll never get back. And Mello and Morrissey should have to pay for that, for taking that liberty from him. So I sure hope that these people start getting arrested. And I'm not the one that wishes bad things on people. I really don't. I believe in karma. I want to see good things for everybody. I want to wish love and happiness and kindness to the world. But these people, in this case, the witnesses, I want to see them go down. Not just the witnesses, but law enforcement, prosecution, all of them, because they are so corrupt. Beverly Canoni is corrupt. Next episode, we're going to talk about how corrupt Bev Canoni is, and that's where I'm going to leave you. So in episode 20, I am going to take you down the rabbit hole of Bev Canoni and why she should have recused herself from the case. So we're going to read a motion from the defense. It was ultimately denied, as we know, but it might shed some light on some things. So with that, I bid you all adieu. I wish you all love and happiness, unless you're a McAlbert. But everyone, I do, wish good, positive, kind things to everyone, and we all should wish positive things on others instead of always being constantly negative and sour about everything. So let's just be positive. And on that note, please hit the like button, and on your way out, please hit the like button, and I will see you on the next one. So take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.